because we do not yet have a quorum, we're going to start as a subcommittee. First bill up is House Committee Substitute for House Bill 301. Representative Roberts, whenever you are ready.
Good afternoon, Mr. Chair, members of the committee. Lane Roberts, House District 161, here to present House Bill 301. There are numerous elements to this bill. If it's okay with the committee, I'll go through each element, and then I'd be happy to take questions about any specific element. First of all, there's a provision here that allows the governor to appoint a special prosecutor who shall serve up to 5 years if the governor determines that a threat to public safety and health exists in a circuit or prosecuting attorney's jurisdiction after reviewing federal, state, or local crime statistics and finding that the number of occurrences of homicide cases in the 12 months immediately preceding exceeds a rate of 35 cases for every 100,000 people within the circuit or prosecuting attorney's jurisdiction. That special prosecutor would have sole and exclusive jurisdiction over first-degree murder, second-degree murder, assault in the first degree, assault in the second degree, robbery in the first degree, robbery in the second degree, and vehicle hijacking. Secondly, the bill requires the Department of Corrections to provide information for inmates who are about to be discharged on how to apply for Medicaid, how to obtain a birth certificate, Social Security card, and state identification. These would all occur prior to release. If the defender does not have access to his or her birth certificate, Social Security card, or state identification upon release, the department will assist them in gaining that. This bill also deals with bail reform and conditions of release. The bill deals with truth in sentencing, which is specific to minimum sentences and the predictability of a sentence. The bill provides for, in the context of sentencing, that allows the court to depart from the applicable statutory minimum if a substantial injustice to the defendant or if the incarceration is not necessary to protect the public. The bill makes an adjustment in the current definition of what constitutes a rifle by removing the words "or adapted." The bill strikes the language that deals with violation of federal law and includes new language that makes the possession lawful if it was lawful according to any state law. The bill makes provisions for a school officer commissioned by a school district to be able to carry a firearm on school grounds. The bill also includes a provision known as Blair's Law. This deals with criminal negligence if a person discharges a firearm within the city limits. The bill makes a definition change in unlawful possession if the person was convicted of a dangerous felony as opposed to any felony. The bill also offers protection for judicial officers or judicial officers' families' personal information. The bill requires that anybody who provides instruction at a Missouri Police Academy would be approved by the Post Commission. And finally, the bill provides for a peace officer basic training tuition reimbursement program as a way to facilitate successful application and training by additional candidates. And with that, Mr. Chair, I'd be happy to answer whatever questions I can.
Thank you, Representative. Just a couple quick ones from me, and then we'll see if anybody else in the committee has any questions. The trigger provision that requires a certain per capita homicide rate in order for the governor to have authority to appoint a special prosecutor, that provision, as homicide rates exist in the state of Missouri, how many jurisdictions would that implicate?
At this point, it would just be the city of St. Louis.
Just the city of St. Louis. Do you know offhand, in terms of Jackson County, how far away the homicide rate is from getting to that point where it would be triggered in Jackson County?
I don't know specifically, but I do know that they're getting dangerously close to it.
Okay, so it would be fairly close to triggering in Jackson
could,
County
yes.
as well. Okay, and then the second question that I have is there's a provision in here that limits the authority of the governor to appoint. Really, it says that they cannot appoint the attorney general. Can you kind of give me a little bit of information on sort of the genesis of where that provision came from?
Right. That provision was specifically included. I think the Prosecutors Association had some concerns with what kind of implications that might mean to whether or not the AG would have the authority to basically intrude on any jurisdiction. So the provision was there in at least in the great part to reassure them that that's not the intent of the bill.
Okay. Do you as the bill sponsor in the House, do you have, would you be open to the idea of removing that provision to give the governor a little bit more flexibility in terms of who he could appoint?
Yes, I would be open to that.
Okay. Any further questions for the sponsor? Mr. Vice Chairman.
Thank you, Mr. Chairman. Thank you, Representative. I've got a couple questions on the felonies. I think that was on page 2. Just curiosity, I didn't catch the executive session on the House bill, but why wasn't 571015 armed criminal action tied into these? Was there any rationale behind that? Because that seems to be an issue in the city of St. Louis and bustling metropolises of these individuals using guns and crimes. And then I'll have a second question piggybacking off of that.
No, I think, frankly, that was an oversight. It should have been there. It's been suggested to me several times, and I would certainly have no objections to including armed criminal action.
And speaking of the issue of firearms and trying to work with both sides of the aisle, I do know it made news of individuals, juveniles, possessing firearms, law enforcement being unable to approach them and figure out if it's a stolen gun, if it's going to be used in a crime, hasn't been used in a crime. I know that there was some talk on maybe an amendment coming on the Senate side. Do you have any insight as to if there's been a deal reached to appease both sides of this argument?
I'm not sure if I would call it a deal at this point, but I have spoken with a number of people both sides of the building. As you may recall, we tried rather hard to find some language that would bridge the Second Amendment provisions and its protections with the safeties in an urban setting in particular. There are instances in the city of St. Louis where children as young as 10, 12 years old, 14 years old are walking around with a Glock in their waistband. That's not what the Second Amendment was meant to protect, and frankly, I don't believe it's a Second Amendment issue to begin with. However, it was voted down in committee, and now that it's on your side, my hope is that we can craft some language that accommodates everybody. In that context, I have provided some language to the handler on this side of the building that would say essentially that if a person under the age of 17 had been adjudicated as delinquent for conduct that would constitute a felony under adult law, then that person would be prohibited from carrying a firearm. The young people who are carrying guns frequently are recidivistic in nature. Mm-hmm. The officers know who they are, and while it doesn't necessarily solve the entire problem, it seems to be language that people on both sides can accept.
Well, I know one of the senators walking in right now, he and I and many others are hoping to thread that needle and fix that issue, to give law enforcement the tools to ensure that minors are not walking around with stolen guns that will later be used in crimes. But I will, now that I think we have a quorum, I will turn this back over to the chair.
Brad, please call the roll.
Senators Lichtmeyer.
Here.
Shore.
Here.
Coleman.
Here.
May.
Here.
Roberts.
Here.
Thompson Rader. Trent. Have a quorum.
We do have quorum. Any further questions for the bill sponsor? Senator May or Senator Roberts?
John, thank you. Well, thank you for being here today. I had some questions about the legislation regarding dangerous felonies and the ability for felons to possess firearms. I believe that was something recently added in the House. Are you familiar with that part?
Yes. This bill came out of a working group that met all summer long.
Mm-hmm.
The charge I was given in chairing that working group was to craft something that dealt with crime in general, that did not leave out the urban areas, and that was bipartisan in nature. In order to do that, we had a 6-member working group. 3 were Democrats, 3 were Republicans. And we made an agreement from the very first that we were going to be open-minded to one another. We were going to listen to each other's concerns. One of the things that grew out of that, as you are undoubtedly aware, particularly on my side of the building, anything dealing with firearms is pretty sacred ground.
Sure.
And so this provision was one of those things that were offered by one of the Republicans on the committee, or I should say on the working group, who felt that prohibiting someone merely because they'd been convicted of, say, hiding checks or some form of fraud, something nonviolent, from possessing a firearm, in their mind at least, sort of flew in the face of the Second Amendment. So that adjustment was made to accommodate their concern.
And I understand that given a situation, as you mentioned, regarding hiding checks, but I just wanted to hit a few of the other ones just so you're aware, because it's a little more serious than that. So that would also include assault second, which would be a situation where someone attempts to cause or knowingly causes physical injury to another person by means of a deadly weapon or a dangerous instrument. So that's not considered a dangerous felony, so that person could still carry a gun. Stalking in the first degree would be another one of those situations. Statutory rape in the first degree if the victim is 12 or 13 years old. And the other would be voluntary manslaughter, which would be a situation where someone knowingly causes the death of another person or the purpose of causing serious physical injury to another person causes the death of another person. So I can understand, situations where it might be a nonviolent felony as the example that you gave, but I think that this is a little overbroad. I don't know if you disagree with that, but I do have some concerns about expanding those to just dangerous felonies.
I think it would be fair to say that I went to some extremes to accommodate the opinions of the entire working group.
Understood. Thank you.
Any further questions for the bill's sponsor?
Yes.
Senator May.
Good evening, Representative, or good afternoon.
Good afternoon.
So I have a lot of questions. You said something I wanted to know. You said it wasn't meant for what the Second Amendment was supposed to protect. In your words, what is the Second Amendment meant to protect?
It's meant to protect the ability to have a firearm. It's not meant to deal with, as an example, I can't cite you the specific piece, but I have read it, know it exists. In the initial discussion of a militia, men were between the ages of 18 and 25 were required to have a firearm. It was rather specific that it was 18 and up. We have had some discussion about whether or not things that are provided for in the Bill of Rights, do we all have a right to do that all the time? Well, I would submit to you that we have a right to vote, but we don't let people vote until they're 18. The argument here is that they don't have the life experience to understand the consequences of their actions. And when you're talking about people who are 10, 12 years old, that's not a Second Amendment provision, that's a maturity decision. And so I don't believe that it was a Second Amendment question at all. It was the same question that would be applied to whether or not a person can vote.
Okay. I'm going to ask you to pull this closer because I'm having trouble hearing you. I don't know if it's
That
because
better?
the wind was blowing so loud. Is your green light on?
It is now. Yeah.
Okay, very good. So, so you're in favor of common sense gun laws?
I am.
Okay. So let me ask you this question. So this trigger that the chair talked about, this 35 per 100,000 cap.
Yes, 35 cases, not 35 occurrences. What we were trying to avoid was not allowing those tragedies where involved mass shootings could distort the data for any given year.
Mm-hmm.
So we're talking about cases,
35 homicide cases, basically.
Yes.
And so, are you aware that in the city of St. Louis, they've always exceeded that for the last 20 years?
Whether it was the last 20 years and where it was at least the last 10 years.
It's the last 20 years. They've exceeded that amount. So my question would be, why now? Who is trying to initiate this piece? Whose idea was this to put this piece of legislation in?
Okay. So there were several people involved. I was involved from the very beginning. I was asked to chair a committee to deal with crime because, frankly, crime has become such an issue in our state. When you get outside of our borders, people think of Missouri as a dangerous place. If you get outside of our national borders, people think of Missouri as a dangerous place. A disproportionate number of those homicides occur in the city of St. Louis, but they're applied to our state data, and it makes the entire state look bad. It affects our economy. It affects the willingness of people to send their children to our schools. It affects the sense of security in your own home. When I looked at that data, the raw data is that on a per capita basis, the homicide rate today in St. Louis is about 2.5 times greater than the homicide per capita rate in Chicago. Now, there's those who would say, well, that's distorted because it's enclaves. It's not the whole city. Well, I would submit to you that St. Louis is the same way. You can find pockets of the community where the rates are higher than others.
I think St. Louis City ranks right up there with Springfield. Or Springfield might be beating St. Louis City in some instances.
If they are, I'm not aware of it. The last time I looked at that data, St. Louis has been at the top or near the top for more than a decade.
So let me ask you this. So do you think that, so you're putting this special prosecutor in, first of all, for City of St. Louis, and basically only, and I'm looking at it as, why are we usurping the vote of the people? And holistically, why are we saying that crime is the responsibility of the prosecutor wholly, and not the police department, not the state legislature, not all of us holistically, and the police, because they have a responsibility? Because as long as I've been in there, we've had a whole bunch of unsolved crimes that are just unsolved and been unsolved and on the books for decades.
Okay, happy to answer that. And I don't want to be argumentative with you, but
Absolutely.
I would suggest to you that
we're not going to be argumentative. We're having a conversation.
The question of whether it's the state or the legislature's responsibility, absolutely. That's why I'm here. It is a part of our responsibility. I would argue that the police could do the best job in the world, but if the case is not filed and it's not prosecuted, it all becomes somewhat moot. It is ultimately the prosecutor's decision whether or not to file a case. And
well, do we have any proof, and I'm just asking you, do you have any documentation of, cases? Because I know during this last couple of weeks, some shenanigans has taken place. But I'm saying prior to that, prior to last week, any documentation as to, the number of cases and what those cases were that was presented to the prosecutor's office that everybody deems were not prosecuted?
I can speak to you in round numbers. I don't have all that document with me, obviously.
Okay.
I can tell you that the last time I was made aware of it, there were approximately 17 prosecutors left in the circuit attorney's office. Of those, 5 do their most serious cases. Of those, 2 had more than 100 cases, and they're supposed to be prosecuting homicides in addition to handling 100 cases. That's impossible. It simply can't be done.
Well, I'm gonna get to that later. This is my other question. So, do you know that? Are you aware that homicides have spiked since 2016 in St. Louis City because the legislature, when we passed the Stand Your Ground law, they went up?
I'm aware that they've gone up since 16. I don't know if I would assign it entirely to that.
I would
suggest to you that prior to 2016, the predecessor to the current circuit attorney filed approximately 8,000 cases. This circuit attorney last year filed 1,600.
Okay. I mean, I'm not comparing, but I'm gonna say this. Are you also aware that since the SAPA law passed in 2020, it has doubled?
Senator, I have gotten quite a bit of criticism because, as you may be aware, when the first version of SAPA came up, I spoke against it and voted against it as one of only 2 Republicans who didn't support it. I did that because I didn't think that the accountability in targeting police officers was appropriate. I didn't get to make that decision all by myself, but the fact of the matter is that in Missouri, the Second Amendment is pretty sacred. And do I think sometimes we go a little beyond? Sure. Absolutely I do. I think most people who promulgated that would say the same thing. but that's not my point. The point is what we're dealing with today. And you can say it's SEPA, but there's an awful lot of other empirical data that suggests that it's more than that.
Yeah, but since, even with all of the articles that was printed and even the challenges by, the Justice Department, the FBI, the police, even the retirement of police officers in reference to SEPA, and even the statistics themselves after it passed. We went from, if you're just talking about what we've done since 2016 to currently, the increase have gradually just increased because we have basically created an environment for crime in the urban areas. We have done that. And so it looks like to me that we're attacking the prosecutor that was elected by the people. See, what I see this part of the bill is as an attempt by the state, you get me, to attack a prosecutor who was overwhelmingly elected twice by the people. And that decision again comes up in August of 2024. And they're not, to me, it's not a requirement or a responsibility of the state to put a supervisor over an elected official that was elected by the people, because I don't remember any people coming to the state asking for help. Because if I'm looking at it, I'm saying that in 1970, it was at 42%. If you look at 1975, it was at 46. 1979, it was at 57. Even if we go recently, if we go back to, 2014, it was at 49. So, when I look at that, I see this as an attack on St. Louis City and African American leadership. That's how I see it, as an attack on.
Understood.
And I know you might not see it that way, and you're looking at it from a statistical basis, but me being in this General Assembly for 13 years, this is exactly what I see. More Jim Crow laws.
Okay. May I respond?
Yes.
Okay. First of all, I didn't come here for the purpose of defending SEPA. I have my own concerns with that.
Absolutely.
And I'm not going to try to argue what I think is pretty obvious in some regards. But I'll say this. When you talk about the prosecutor who was elected twice, overwhelmingly, talk to the people who are left behind when their loved ones were dead and see if they feel the same way. Talk to the people who don't feel safe in their home and see if they feel the same way. Talk to those who've been robbed or assaulted and the people who commit those crimes are not being prosecuted. Ask them if they feel the same way that you do.
Well, I have those meetings every week in my community.
And do they tell you that they support this prosecutor?
They're not blaming it on the prosecutor. They're blaming it on the police.
And what do the police do when they file a case with the prosecutor and she doesn't file the case?
Well, that's where we have that again. I think there's a miscommunication or a misnomer when we're saying when the police file a case to the prosecutor and the prosecutor is not filing the case. Because, see, you have judges in there, because I have seen where the prosecutor have filed many cases and asked for extension for more investigation so investigators can go out and get more information. And I've seen where the judge would not allow a continuance in a whole lot of those cases and force the prosecutor's office to drop those cases and have to refile. So I'm looking at this as a holistic assault. And you probably, I don't know if you were in the legislature when all of this happened, but it's a lot of stuff that has led up to this that the Missouri legislature is attacking this prosecutor specifically on. And it goes back to the Governor Greitens situation. So if we're continuing, so I have to look at this deeply, trying to figure out, are we really trying to solve an issue? Or are we really just attacking this prosecutor because we are offended, or, we need to put her in her place because of the actions that she's taken or stood?
I can only speak for myself.
Absolutely.
And I'm telling you that I was a part of this discussion from the very beginning. I've never met the prosecutor. Frankly, I don't care about gender or race or whether or not she likes broccoli. It doesn't matter to me. What matters to me is that the people committing these offenses are not being prosecuted. And I will point this out to you. Prior to her being in office, the average number of requests for warrants was about 400 at any given time. It has been over 4,000 under this prosecutor. Now, we can talk about reasons for that all we want. But it is hard to argue that the number of people, the number of warrant requests is 10 times greater than it was before her time.
Well,
I
let me
only
tell-
care about her performance. The rest of it is really of little interest to me at all.
But let me put something else on the table. How long have you been here in the legislature?
5 years.
Okay, so let me put something else on the table. That's why I say why now, because these statistics were the same prior to her taking office. But let me just lay this on the table too. To me, we're in the city of St. Louis, which has always been a predominantly African American city since I've been, growing up, and we've always seen justice through the eyes of Caucasian people who has the idea that locking up, we went from slavery to incarceration, and that has not changed for African Americans. And so now Caucasian Americans, white Americans, are seeing justice through the eyes of an African American who has created a lot of criminal justice reform ever since she's been in office, which the voters wanted. So I don't know if I can compare those statistics and say, we have to look at those statistics through a different lens and not just numbers. But thank you anyway for your questions and your answers. I appreciate it.
Right. If I could, I don't dispute what you're saying at all. I understood from the very beginning that no matter what I did, that the question of whether or not this was somehow racially motivated was going to occur. I can tell you that didn't occur with me.
Oh, I know
I'm not gonna
that
speak for anybody
because I
else.
know you.
I also would say, you asked me why now. I was approached, and you're going to hear from some people here today who will tell you that they came to the legislature because crime in this state is affecting our economy. It's spilling over St. Louis's borders, and it does affect the rest of us. I love my state, and I care about whether or not we can attract business or whether or not people are going to come to our academic institutions. I care about that. So it isn't something that just occurred spontaneously. There was, in fact, people who approached us and said, we've got to do something about crime in Missouri.
Yeah, but I know those people, they have a political agenda, and I know some of those same people might have came to you. Me and you have a private conversation about who those people were, and I'll tell you what their political agenda was. Thank you.
You bet.
Representative, I want to touch on something very briefly that Senator May raised, and that's the issue of causation. What's causing the crime rates to spike? I think her suggestion and narrative would be that somehow it's pro-Second Amendment laws that have been passed by the General Assembly. She specifically mentioned SEPA, which was passed in 2022. Do you know the year where there was the highest on-record homicide rate in the city of St. Louis since 1970? What year that was?
I think it was back in the 90s, as I recall.
2021.
2021.
Okay. So the year before SEPA passed was the highest homicide rate since 1970 in the city of St. Louis. And would you care to guess, if you look from 1970 to present, for the 10 highest years of record crime in the city of St. Louis, how many of those years, 10 years of the highest homicide rate in St. Louis, were under the watch of the circuit attorney? Bear in mind, she's going back to 1970. She has been in office since 2017. How many years of the 10 years of the highest homicide rates are on her watch?
I believe it's virtually all of them.
It's 6.
Yes.
6. So she's been in office 17, 18, 19. She's been in office for 6 years. 6 of the 10 highest homicide rates since 1970 coincide with the 6 years that she's been in office.
And it also
Now, I think, Senator, I think if we want to talk about causation, it's difficult to make a credible argument that the circuit attorney and her failure to prosecute cases, her conviction rate, which is 50%, which is one of the lowest conviction rates in the United States of America. I think there's only one prosecutor in the country, the prosecuting attorney in the city of Orlando, who has a more abysmal conviction rate than Ms. Gardner. And so the notion that somehow she is not partly responsible, I'm not saying that there aren't multiple factors causing crime in the city of St. Louis, but that she is not partly responsible, I think lacks credibility.
Senator, I was a police officer for 43 years, and I can tell you from personal experience that when you fail to prosecute the people who commit crimes, it feeds on itself. When there is an aura of confidence among those who would break the law, that they're not going to be held accountable, it feeds on itself, and it grows almost exponentially. And that's not just St. Louis, that's anywhere across the nation. I've been a police officer in 3 different states. It is always the same. Unless there is the willingness to take the person who committed the crime and separate them from the innocent people, those innocent people will be victimized.
Senator May.
Yes. So, just to go back to what he said, we removed constitutional conceal and carry before we passed Stand Your Ground. That was around 2015 and 2016. So the increase, like I said, is still a responsibility of the legislature, because we argued that those movements by the legislature will affect the urban areas. Absolutely. That's the truth. So even SAPA passed in 2021, I do believe. That's the year it passed. That's why you have that spike, because it passed during that summertime. So it was 2021 when it passed. So, we can argue semantics. Me and you had this discussion a lot, but it's the responsibility of this legislature who removed conceal and carry in the state, where nobody had to go down there and spend 8 hours and get gun. And then you passed Stand Your Ground law in 2016. So that's why you have this increase, because the law's effect took time to come into effect. It's not because Gardner was in office, because before that it was high, and this legislature, and I'm sure you were probably here, didn't decide to put in a special prosecutor at all. Thank you.
Further questions for the bill sponsor? Senator Coleman.
Thank you. Just briefly, there's been concern with some of our other counties dealing with a failure to prosecute crimes against children, in particular Cedar County, where there's been some atrocious crimes that have been brought. The AG did a significant amount of investigation, and that prosecutor has been systemically dropping those charges. Are you willing to talk about that as well as part of this bill?
To the extent that it will fit, yes.
Thank you.
Yeah.
Any further questions for the bill sponsor? Senator Roberts.
Thank you. I just want to add on to that from a personal experience. I do have a question at the end of this, but we're talking about the effect of the legislature. I was serving as a prosecutor in the city of St. Louis when constitutional carry came into effect. I had law enforcement officers for several weeks bringing me cases that the weeks before I could issue that I no longer could. These would be situations where an individual would be arrested for unlawfully possessing a weapon without a permit. Because of the basis of that search, they found drugs and other contraband. I could no longer issue those cases. So I have directly seen the impact of constitutional carry in the city of St. Louis. And that is one of the reasons why our officers see folks out there knowing they have a concealed weapon on them, and probably someone who shouldn't have one, and there's nothing that they can do. It's like putting a stoplight at an intersection after you've got 3 kids who've been run over. But to my question, you'd mentioned, and you said several times, what do we do when you have a situation where you have a prosecutor who the law enforcement officers are bringing me a case and they're refusing to issue it? But nowhere in this bill does this talk about cases that are pending with the prosecutor's office. On the first page, lines 4 through 6, finding that the number of occurrences of homicide cases in the 12 months immediately preceding exceeds the rate of 35 cases per 100,000 people within a circuit or prosecuting attorney's jurisdiction. So this could be a situation where the police have no idea. They know someone was murdered, but they have no idea who committed that murder. How can you hold the prosecutor responsible if they're not even applying on that case? And that is the factor that is being used under this legislation.
Okay, so I'm afraid there'll be those who just choose not to believe me. But this is a case where, in my mind, we are going to help the circuit attorney's office whether she wants it or not. And that's exactly how I feel about it. In order to prosecute murders requires both experience and time. You have people who have been in jail for 2 years for homicides and have never been prosecuted. How can that be? How in a justice system that talks about a speedy trial, in a justice system that says we're going to assume somebody is innocent until proven guilty, how can someone reside in a jail for 2 years without being tried? And how can more than one of them be in that circumstance? The point that I'm making is this. Why this has occurred, we can talk about why all day long. But the end result is more than 1,000 people have died in St. Louis in the last 5 years. Thousands more have been assaulted on a felony level. People are afraid and insecure in their homes, and the people doing it are not being prosecuted. And why that's occurring, we can have those discussions forever. My intent is to provide a resource that's going to focus on those specific elements and do that part. Now, it doesn't replace the circuit attorney. There are some 3,000 warrant requests that the circuit attorney currently has that staff could then focus on, because now we've relieved a portion of that workload. Again, I understand this is not a simple issue. I wish I could tell you that A, B, and C are the cause of this, so let's fix them. But that's just not the way it is. What is the situation is that we've got a huge violence crime problem in St. Louis. This is something that I can do about it. And I would point this out. I worked on that bill all summer long. I pre-filed it in December. Not one single person has offered an alternative to this beyond this one bill, which tells me there's not much more out there.
Well, and I agree with what you're saying. You can't have people just sitting there indefinitely. The cases need to go to trial. And I do understand that you come from a genuine place, and I appreciate the thought of what we're trying to do here. However, that doesn't address how this is written. And that's kind of my main point. So it's two different arguments as far as saying, look, we've got these pending cases that the prosecutor's issuing versus, we've got X amount of murders. We have no idea who committed those murders. So, I mean, if the focus is, hey, there are these cases that office is sitting on, this legislation does not read this way. This talks about murders as a whole, whether have a murder suspect or don't. And the other part I'd like to address with you briefly. It talks about line 12 on the first page. The special prosecutor shall have exclusive jurisdiction to initiate and prosecuting the following felony offenses. And then it talks about their funding as far as that. So exclusive jurisdiction. So if, for example, if this were to go into effect, I would imagine that if you're taking away the authority of the circuit attorney to prosecute any of those enumerated offenses, if this isn't funded, how would these cases then get prosecuted?
I have no doubt about the funding.
All right. So is that a correct reading of it? You're saying that the circuit attorney would be prevented then from prosecuting the enumerated offenses in line 14 through 20, or I guess superseded?
Not sure the phrase I'd use is preventing, but certainly it would be the purview of somebody else, yes.
All right, thank you.
One other question, follow-up question.
Senator May.
So tell me the constitutionality of us being able to supersede the vote of the people. So because if we look at the Constitution and the First Amendment of the Constitution, it says by the right of the people and their right solely. So I'm trying to figure out, is it constitutional for the state to supersede the choice of the people?
Well, I would argue that the answer is yes. First of all, we are not superseding the will of the people. We're not removing the circuit attorney.
But you're nullifying their choice.
Well, we are bringing to the table a resource that she doesn't currently have. That's true.
But you're nullifying her. So for me, if you were saying to work alongside of, but you're saying exclusive jurisdiction, and you're taking her ability that she has been elected to do to prosecute those cases, you are actually putting this person in a supervisory role over the elected prosecutor.
The special prosecutor would have absolutely no supervisory responsibility for the circuit attorney. None.
So are you saying that your bill is allowing the prosecutor will still be able to prosecute those same enumerated defenses?
No, what I'm saying is the special prosecutor would have sole and exclusive jurisdiction over those crimes. Circuit attorney would have exclusive jurisdiction over everything else, and the special prosecutor would offer no supervisory role.
Okay. If I was an attorney, I would take you to court. All right. Thank you, Representative. Thank you.
Any further questions for the bill sponsor? Hearing none, and after that threat from Senator May, it's a good thing we're getting you off the hook here.
Not here while I
First
can.
witness in support of House Committee Substitute for House Bill 301.
Good afternoon. My name is Joe Steiger. I'm a retired St. Louis City police officer. I worked for the St. Louis Police Department for about 22 years. I'm currently the business manager for the St. Louis Police Officers Association. I'm also a member of the Fraternal Order of Police and the St. Louis Police Veterans Association. I'm here on behalf of all three organizations to show my support for House Bill 301. As most of us are aware, the St. Louis Circuit Attorney has been in the news quite a bit here recently. The past few days, due to the recent tragic incident in downtown, the entire situation could have and should have been avoided if not for the ineffectiveness of that office. Janae Edmondson isn't the first victim who's been affected by Ms. Gardner's failures as Circuit Attorney, but hopefully she will be the last. Crimes are not being properly prosecuted in Ms. Gardner's office. In 2019, only 1,641 of the over 7,000 felony charges sought by the St. Louis police officers were prosecuted by the Circuit Attorney's Office. That number dropped in 2020 to 861. Since Ms. Gardner took office, the number of criminal cases dismissed by city prosecutors has steadily increased. Prior to her control, on average, about 10 to 15 felony cases were dismissed. Since Ms. Gardner's control, that average has jumped over 30% of all felony cases dismissed by prosecutors. In addition to that, the Circuit Attorney's Office loses about half of all the cases it takes to trial. Before Ms. Gardner was in control of that office, that number was closer to about 30%. There's a massive backlog in the city's prosecution system. There's some dispute over the number of cases, but according to our data, as of January 1st of this year, there were over 4,000 outstanding cases. Those are defendants who have been released pending application of warrants. Those are individuals who are released free to roam the streets of St. Louis until the case has been reviewed. These cases don't just include nonviolent or victimless crimes. The numbers also include over 200 violent felonies, including assault first, assault second, robbery first and robbery second, domestic abuse, kidnapping cases, and others. Another contributing factor to the failures in the Circuit Attorney's Office is the staffing issues. The office has experienced a 100% turnover, operating with approximately a third less of the staff, the prosecutors, that they had prior to Ms. Gardner's election. More than 65 prosecutors with over 450 years of experience have left the office under Ms. Gardner's watch. This has led to an inexperienced and overworked staff. One example of that here recently, about a year ago, there was two police officers who were received a call and were investigating a holdup at a check cashing place on Grand Avenue. When the officers arrived on the scene, the suspect was leaving the business with a pistol. They confronted the person, asked him to drop the weapon multiple times. He did not. He chose to fire, and that resulted in the officers returning fire in defense of their lives. His actions resulted in him being paralyzed. The Circuit Attorney's Office called the officers the day of a hearing to inform them that that case would be sent to drug court and that person would be given 3 years probation. The officers, nonetheless, the officers were upset with that, and myself and them wrote letters to the judge asking her to consider. She addressed that with both the defense attorney and the prosecutor, which led to that case has now been, that deal's been pulled, and they have returned to a trial docket. St. Louis City officials have even begun to turn on Ms. Gardner. This last incident with Ms. Edmondson was apparently the straw that broke the camel's back. While these same city officials who once supported her may not welcome the solution being considered in this committee today, almost everyone is certainly in agreement that it's time to try something different. The men and women of St. Louis Police Officers Association want to thank this body for taking the initiative to try to address the crime problems in St. Louis, and more specifically, to deal with the issues that are directly related to the lack of prosecution and incompetence in the Circuit Attorney's Office. Something needs to be done before we have yet another tragic and horrifying incident caused by the failures of that office. I thank you for listening to my comments, and I'm happy to take any questions.
Thank you for your testimony. I had a quick question. I want to go through just a couple of statistics, though, before I ask it. These numbers are actually from Miss Gardner herself. She recently, in a interview, said that this is in 2019, that 60% of the 5,000 cases brought to her by the police department were ultimately not charged. I'm going to ask the prosecutors in a little bit how that would compare to other jurisdictions. Notably, that 60% excludes what we know are very favorable plea deals that a lot of individuals are getting, where they're going on probation after committing a dangerous felony offense. The acquittal rate, which you touched upon earlier in your testimony, where she's losing about 50% of the cases that actually go to trial, which again is one of the lowest conviction rates in the entire country. And the question that I have for you is, what moral impact does that have on police officers whenever they put their lives on the line to go out into the community to arrest a dangerous individual, and then they find them back out on the street?
Yeah, morale is certainly at a low. Again, this case this week, I don't mean to keep harping on it, but it started to resonate a bit. The rest of the community is starting to see what police officers see every day. Morale is very low. It's not all, there's a lot of contributing factors to that, but this is certainly part of that.
I just assume that if you pick up a dangerous person on the street and you risk your life, and then because of the ineffectiveness of the circuit attorney, you have to go out and potentially rearrest that dangerous individual again. I mean, that takes a huge emotional toll on a police officer, I would assume.
Certainly does.
Okay. Any further questions for the witness? Senator Schroer.
Thank you, Mr. Steiger, for coming again to testify on something I think is very important to our state, our region, no matter what side of the political aisle you're on. Piggybacking off of the chair's inquiry, I want to tackle how many cases are being turned over versus how many are actually being touched, how many are being prosecuted. As of right now, do you have any idea of how many cases collectively as a whole, whether it's violent crime or petty crime, that law enforcement has turned in, done their due diligence, investigated it, and found out who the perpetrator ultimately could be, and turn that over to the circuit attorney's office?
Yes, sir. So, again, the numbers are kind of fluid because every 2 years that changes. So, cases drop off. So the current pending application and warrant list lasts about 2 years, and then so every day it would be different. But the last numbers that we had go back to the first part of this year, and it was 4,458 outstanding cases. That included all crimes. It was not just violent crimes. As I mentioned, it was about a little over 200 of those were the violent crimes that I mentioned. But overall cases, that was the last numbers we had as of January.
And you had 4,000. Did you say 4,458 outstanding cases?
Correct.
Of those, almost 4,500. How many are murders?
That I don't know of the murder charges. Of the 208 of them are the violent felonies that fall in that classification.
So, and I know it was somewhat alluded to that, we've created this environment for crime to flourish. And I don't know how broad of a statement that was meant to be, but we have. I think in 2019, of the 7,045 felony charges that were brought forth from law enforcement, only 1,641 were acted upon. In the years thereafter, we have seen in surrounding areas, including St. Charles County, where almost 65% of the arrests that were happening in St. Charles City were attributed to individuals that were coming over from St. Louis that had prior criminal histories that should have been locked up, like we've heard about this gentleman over the weekend. And looking at the victims, because I know it was alluded to that this is another enactment of Jim Crow laws, which Jim Crow laws were meant to marginalize black citizens by denying the right to vote, to receive education, jobs. Anybody who defied them were treated very poorly, arrested, beaten. When we look at the victims of, and I'm looking at some stats here from 2017 to now, the victims of these homicides in the city of St. Louis, do you have any statistics on how many of them are black versus how many of them are white?
I don't have the numbers in front of me, but it is predominantly African-American victims.
Well, I do have the numbers here, and yeah, it's predominantly black Missourians are being murdered in droves which is equating to, if you're not touching these cases, if the circuit attorney is not touching these cases, we have these lives that are being lost, with the murderers still left out on the street to commit further harm to these black communities. So I think by doing nothing, or by allowing the status quo to continue, we are allowing Jim Crow laws to affect our areas once again. I think these areas should be treated the same as St. Charles County, Jefferson County, Clay County. If you break the law, we need to work with law enforcement, work with the prosecutor's office, and treat everybody accordingly if they broke the law or not, and investigate this. This is harming our communities. It's harming the people. They are fleeing. Businesses are fleeing. And in your line of work, it's hard to even get recruits to come to the city of St. Louis. So I thank you again for your time, and very willing to work with you and anyone else to make St. Louis safer.
Thank you, sir.
Senator Coleman.
Thank you, Mr. Chairman. I just want to thank you for being here. I represent Jefferson County, and we have seen an increase in the prosecutions that are happening in my county of individuals who have existing crimes in the city of St. Louis. In fact, the majority of those that are prosecuted in my community now have outstanding charges in the city of St. Louis as well. And just want to thank you for being here and say I find it absolutely reprehensible that although we're here talking because of a crime that took place on a young person who is a visitor, we have 208 other victims, what percentage of which are citizens and are Missourians, and that it took somebody who was out of state to be a victim for us to be able to finally be moving forward. I find it just absolutely reprehensible. So thank you for the work that you're doing, and thank you for testifying in support of this bill, because it affects not just St. Louis City, but as well as the surrounding collar communities and the rest of Missouri.
Thank you. Any further questions for the witness?
Absolutely.
Senator May.
So when we, because I'm just, listening to this conversation, and it amazes me how everybody else have no self-awareness. It amazes me. And in the city of St. Louis has been polarized ever since I've been there. And police officers have not been the friend to African American communities as long as I've been there. You get me? And so, and these relationships have always been challenged. And before Circuit Attorney Gardner took office, you had other prosecutors. And it amazes me how this legislature didn't step up when you had a Jason Stockley. You got me, who the prosecutor arranged to go to California without even standing trial, brought no charges against him. So, and then you have, doing the protest, when they assaulted their own officers and got away with it, the courts let them out. So, and I want to set the record straight, because you weren't accurate when you said that Attorney Gardner was the one. The attorney representing the young man even put out a statement that in this case, her office did nothing wrong. He argued that his probation or parole be not revoked, and she argued that it should be, and the judge made the decision. So we want to make sure that we get the record correct in this instance. So we don't want to put false information out there in making this young lady like she was responsible for what happened to her. That's a big stretch. But when we're talking about dismissed cases, so when I was in the House, we had a conversation about St. Louis City, St. Louis County, all of the jails who were holding individuals for trial. And we had that they were being held more than 2 years prior to this even happening, because Governor Greitens was concerned about that as well when he hired the new director of corrections. And we fixed the problem in budget, and it was a problem that we had back then. So, I just want to make sure that we have, but this is my one question for you. Because you mentioned, you're talking about cases not being tried and filed. Aren't witnesses not coming forward?
Well, that's certainly part of
That's
issue.
part of it. Mm-hmm. And what about insufficient evidence?
I'm sure there are cases of that as well.
Absolutely. And when you said Prosecuting Attorney Gardner took the office, I want to know, you talked about prosecutors fleeing the office. What are the demographics of those prosecutors that left the office?
I don't know that information, ma'am.
Right. So, so the reason I say that is because, we have historical challenges in this state when it comes to race relations. You get me? And we got to fix it all, because we got to have that come to Jesus moment for police, citizens, and all of that in order for us to fix this problem, because this problem is bigger than Kim Gardner. It's really bigger than her. But when African Americans become leaders, become the boss, normally you have white flight. It's just like in the communities. When we began to migrate in certain areas that African Americans weren't allowed, then we noticed white flight. They would leave those areas. And then not only that, the leaders, and I'm holding all of them accountable because they've had this conversation with me before. The leaders and the disinvestment in the areas that foster the crime. That's why Hayden created the Hayden's Triangle. Those are the communities that have been least invested in the community. So the reason I'm having this conversation is because you're making it like it's one person when it's a holistic contributory factor in the reason those cases are the way they are. And you have to look at each one of them individually, and you can't compare to prior to her, because when you're looking at judges and their relationships to prosecutors, this is an issue in the city of St. Louis, because when she first got elected, it was an issue, a racial issue happening with judges when she got elected. And this is a fact. So I just want to say that all of this is contributory.
Any further questions for the witness? Senator Roberts.
Thank you. Thank you for coming up to testify with us here today. A few weeks ago, we saw a widely reported incident at the city foundry where two children, their ages 15 and 16, they were involved in an incident where officers found a Glock 19 with an auto sear in their position. They were released without punishment. Is there anything under Missouri law that prevents those kids from carrying that firearm?
I can tell you that certainly is an issue for our members that have the juveniles in possession of weapons, and it's good to hear the conversation here today with some of both sides of the aisle, both the Senate and the House, about willing to address those types of issues, and we would certainly like to sit down and be a part of that solution.
Because that's the biggest issue that I'm seeing right now. I mean, it's not the circuit attorney out committing crimes; it's people with guns. And if we want to have a serious conversation, the conversation is, what do we do about these guns on our streets? Thank you.
Yes, sir.
Any further questions for the witness? Seeing none, thank you for your testimony. Please don't forget your witness form. I know we have out in the hallway the Prosecuting Attorneys Association, which I believe is going to be on record testifying in opposition. If we could let them come in, we're going to kind of go back and forth between pro and con. So the Prosecuting Attorneys Association.
Mr. Chairman, members of the committee, I'm Eric Zahn. I've had the great privilege of serving as the Platte County prosecuting attorney for the last 20 years.
The St. Charles County prosecuting attorney, as well as a member of the Missouri Association of Prosecuting Attorneys Board of Directors.
And we are here today speaking on behalf of the MAPA, Missouri Association of Prosecuting Attorneys Board. And we'd both like to make some opening comments, and then we'll be happy to take your questions. Before we begin, I think it's clear that everyone is shocked and saddened by the horrifying injuries suffered by Janae Edmondson at the hands of Daniel Riley, a man who never should have been out of jail to harm her. And while neither Mr. Lomar nor I nor our association will take sides on the many issues plaguing the city of St. Louis, we're concerned for the citizens of the city and their right to justice and public safety. But to be clear, we're not here to defend or to demonize the Circuit Attorney of St. Louis. We're here instead to discuss this bill in front of this committee, which is not limited to the city of St. Louis. It's a bill that could impact every independently, locally elected prosecutor in the state of Missouri. The position of the Missouri Association of Prosecuting Attorneys is that House Bill 301 is both unnecessary and counterproductive. And let me talk about both of those things, and then I'm going to allow my colleague, Prosecuting Attorney Lomar, to talk about what MAPPA remains prepared to do to assist in the city of St. Louis. As we already know, Missouri law already provides a statutory mechanism to remove a prosecutor who neglects his or her duties. In fact, we know that because just this last week, the Missouri Attorney General has utilized that law. It goes by the Latin term of quo warranto. He filed a petition to remove the St. Louis Circuit Attorney from her position. That is the time-tested way to remove any local official, including a prosecutor, who fails to carry out the dictates of the law or uphold the will of the people who elected them. Quo warranto is found in Chapter 106 of our statutes. It allows any person, including in this instance an attorney general, to file suit against any elected official, including a prosecutor, who neglects or willfully abandons the duties of their office. In this case, what's going to happen is a judge, after hearing all of the evidence, will determine whether or not the St. Louis Circuit Attorney has failed in her obligations and should be ousted. Should the evidence prove convincing, she will be immediately ousted from office, and a newly appointed Circuit Attorney will take her position. Now, by way of contrast, House Bill 301 does not permit any immediate ouster of a prosecutor. Instead, only after the governor would act sometime on or after August 28th, and it would still leave the Circuit Attorney in place to prosecute the vast majority of crimes in that jurisdiction, or a prosecutor in any other jurisdiction. Now, because Mr. Lomar and I, like the Attorney General, both represent the state of Missouri, it would be inappropriate for us to comment in detail on the merits of that case. However, I will say we trust the process. I myself have used this very remedy to oust the mayor of a city in Platte County. I can tell you that statute works. So the existing remedy there in Chapter 106, which is being utilized even as we speak, provides the proper, effective, and tried and true remedy for any local official, including a prosecutor, to be removed should they fail to uphold the duties of their office. But my fear is this. House Bill 301 is not just unnecessary, we believe it also would be counterproductive. We've already mentioned that it would leave the offending prosecutor in place in any jurisdiction to prosecute the vast majority of crimes. Many assaults, all drug crimes, the overwhelming number of weapons offenses, all sexual offenses, all property crimes would continue to be handled solely by a prosecutor who, by definition, the governor had decided was incapable of successfully carrying out the duties of his or her office. House Bill 301 would actually leave the offending prosecutor in place to prosecute, or at their sole discretion not to prosecute, the vast majority of cases in a jurisdiction. That doesn't seem to make a whole lot of sense, particularly when Chapter 106 already provides a mechanism to completely oust a prosecutor who is failing. Second, unlike the immediate effect in Chapter 106, House Bill 301, if enacted, would only take effect, again, at the earliest on August 28th, and even then, if the governor were to act on that first day the bill became law, the special prosecutor would have to be appointed, would then have to hire assistants, which I can tell you in this environment is no easy task. Nearly all of my colleagues are already short on prosecutors, and of course these prosecutors, because they'll be prosecuting some of the most difficult cases, would need to be experienced prosecutor. Then that prosecutor would need to obtain, review, and begin to prosecute all of the murders, assaults, robberies, and vehicle hijackings in that jurisdiction. In this case, we all know we're talking about the city of St. Louis. That's going to take a period of months. Should House Bill 301 pass, we need to be prepared to wait many, many months for anything at all to change in the city of St. Louis. Third, while, again, the focus of this bill is undeniably on the city of St. Louis, it's not limited to that jurisdiction, and it would apply to any jurisdiction in the state. And I want you to think a little bit more about that criteria for a homicide rate of 35 out of 100,000. That would be met in many of our rural counties in a single multi-victim homicide case. It seems counterproductive to consider the appointment of a special prosecutor just because one murderer kills multiple people in a single homicide event in a rural jurisdiction. Fourth and finally, before I yield to my colleague, I hope this body will think very hard about the precedent set by House Bill 301 before passage. People are rightly concerned about what's happening in the city of St. Louis. But Missouri, like the vast majority of other states, has a system of independently elected prosecutors for a reason. Those prosecutors are elected by their local communities because community standards can vary. What people in Platte County want may be different than what people in St. Charles County want, or people here in Cole County, Jefferson City, may want. We worry that if the legislature today puts in place a mechanism for a governor to appoint a special prosecutor because that governor doesn't like what's happening in a particular county, what happens when the governor's office changes? Think, for example, of a governor who opposed the death penalty or is pro-abortion. As written, assuming the minimal statistical requirements are met, this legislation will allow a governor, without any check from this body, to appoint a special prosecutor to handle those very cases because the governor happens to disagree with the way a particular prosecutor is exercising that jurisdiction to pursue or not pursue the death penalty or charges against an illegal abortion provider. So, in short, we believe that existing law already provides a solution in this situation, and we worry that this bill could be counterproductive and tie the hands of locally elected prosecutors who have served this state well since at least 1875. Let me now yield to Prosecuting Attorney Lomar to talk more about what MAPA is prepared to do.
Thank you, Eric. I would just say there's not a great deal I can add that's not already been stated, but we are here today not to defend or protect a particular individual, but rather the institution. We believe that the proper proceeding is in place, and the Attorney General has followed that, and however that plays out is the way it should play out. I will say, in the event of a vacancy in the Circuit Attorney's Office, our association, which is comprised of 114 elected prosecutors from around the state, are prepared to volunteer our services, donate our staff, our manpower, and womanpower to step up and assist so that, because as Eric said, if there is a vacancy in the Circuit Attorney's Office, it will be quite some time before that vacancy is filled. And what's to say what will be left of that staff. So we are prepared to do so. We have all the largest offices in the county, I should say in the state, have committed their resources to that end. Aside from that, I thank you for the privilege to testify.
Thank you for your testimony. So I do understand one of the objections here is, it's a slippery slope. It could expand to other prosecutors when, we're clearly here to address a situation that's sort of unique to the city of St. Louis. As you both know, we had a special session a couple of years ago where a bill actually did pass through the Senate that would have granted concurrent jurisdiction to the Attorney General, limited just to the city of St. Louis. As between those two provisions, based on your testimony, would it be accurate to say that the prosecutors would be less opposed to a provision that's cabined to the Circuit Attorney's Office as opposed to one that is triggered by homicide rates?
Well, since you're smarter than me, you can answer that question.
I don't know that it's true that I am smarter than him, but the association is concerned with the potential statewide impact of this bill, and so I think it's fair to say that the statewide impact animates a portion of our testimony.
And then the second highest jurisdiction, you had, setting aside the law school, what I'm going to refer to as the law school exam example, where there's a mass shooting in a small county that would automatically trigger the provision. Just based on homicide statistics that we have available right now, I assume that Jackson County would be the county that would be closest behind the city of St. Louis in terms of jurisdictions per capita.
I assume that's true. I don't know those statistics off the top of my head, Senator, but I assume you're correct there.
Okay. So am I correct in assuming that we don't, as we sit here now, you don't know how close Jackson County is to triggering under the proposed statute?
I just don't. I have not looked at those statistics.
You mentioned the writ that was filed by the Attorney General's office. What do we know in terms of the timing of a quo action, how quickly those are resolved?
I know that the Attorney General is going to ask that it be heard in an expedited manner. Ultimately, that's going to be up to the court. The interesting thing about quo proceedings is that there are relatively limited rules on how those work, and so ultimately the court will decide how quickly it will be heard. But I know the Attorney General wishes to expedite that matter.
And I'm correct in assuming, as it is the case with most writs, the circuit attorney will have 30 days to file her answer.
That's not necessarily true. No, I will tell you in the writ that I spoke of that I filed in Platte County, there was not 30 days to file an answer. So no, it doesn't have to be a 30-day delay, Senator.
Okay. And then in terms of, again, back on timing, we've got roughly 2.5 months left in the legislative session. Is it reasonable to expect that a quo action would wrap up in that short of a time frame?
I think it's possible, but not entirely likely.
Okay. So we are probably going to leave this legislative session, regardless of whether we pass or do not pass this bill, not knowing the resolution of that particular case.
I think that's entirely likely. Again, it's possible it could get resolved within that 2.5 months, but as we all know, Senator, you're an attorney too, you know that the wheels of justice can grind slow.
Yep. In terms of there's been a lot of references to some statistics specific to the Circuit Attorney's Office today during the hearing. In your experience, and this question would be for both of you, what is a normal rate for cases that are referred to a prosecuting attorney's office to not be charged?
I would say our rate in St. Charles County hovers between 25 to 30%, meaning that we would file on 70 to 75% of the cases that are referred to us.
Okay.
Ours would be very similar in Platte County. Now, I will say every jurisdiction is different. In some counties, there are witnesses who are more cooperative than in other counties. It's based on a whole bunch of different factors, but our statistics would be similar to what Tim has said in St. Charles County.
Okay. And then what about conviction rates for cases that are actually charged and taken to trial? What would be the normal conviction rate that would be experienced among most prosecuting attorneys' offices?
Tough to answer that question because we have cases and then we have counts within each case, as I'm sure you know. So if your statistics include a guilty plea to a certain count but a dismissal of other counts, that's going to skew the numbers one direction. If you're talking about just cases by themselves that we file and there's a finding of guilt, I would venture to give you my educated guess, which would be in excess of 90%.
Ours would be in excess of 90% too. But again, I would caution this body that every jurisdiction is different, and jury pools are different, judges are different in different places. But ours would be similar to St. Charles.
So would it surprise you to learn that Ms. Gardner's conviction rate between September 22nd and February, or September of 2022 of last year and February 23rd of this year has been 50%?
Would that surprise me? It would not. But I would echo what Mr. Zahn says. Unfortunately, there are a lot of players in the city in terms of law enforcement, and each of those institutions bears some degree of responsibility. So it's hard to pinpoint just one office as being solely responsible for that, in my opinion.
So what would be the other offices that would be responsible for a 50% conviction rate?
Well, you get the Judiciary. I don't know to what extent we have trials that resulted in not guilty verdicts or cases that were dismissed prior to trial. So those are variables that you need to explore. The obvious issue that I don't have in St. Charles County, that Eric doesn't have in Platte County, is we have a witness pool that generally is very willing to cooperate. And I know that is not the case in the city of St. Louis. So all those things, I think, are at play for a relatively meager number.
Any questions for the witness? Senator Schroer.
Thank you, gentlemen, for coming today. I want to kind of piggyback again off the chair as he asked a lot of the questions I had as well. I'm very familiar with your work in the past, trying to get some assistance to the Circuit Attorney's Office. Is it true that in the past you all have, as the Prosecutors Association, have offered help along with the Attorney General to come in, knowing that there's a lot of turnover, there's a lot of opportunity to tackle some of these cases that are sitting there? What was the outcome of you all offering this help in the past?
Well, I could say specifically from my perspective, both on behalf of the association as well as in my individual capacity as an elected prosecutor just a few counties to the west, we did offer help, not in any specific form in terms of numbers of people or number of hours or anything like that. Right about that time, I believe the circuit attorney attempted to get a special prosecutor appointed on a death penalty case, if I recall.
That was the officer that was killed.
It may have been that one. This would have been August of 2021, and
I think that was the David Dorn case.
Might have been.
Okay.
And yes, I think you're right. As a matter of fact, and the basis of the motion for the special appointment of special prosecutor was, I'm paraphrasing, but a lack of resources, and the court determined, I think rightly so, that a lack of resources is not sufficient grounds to have a prosecutor removed. So, following that court's decision, I believe it was the position of the Circuit Attorney's Office that they could not reach out and obtain the help from us that we offered. Now, there is another way we can do that. We don't have to be a special prosecutor. Statute allows either of us, for example, to appoint a special assistant to cooperate or help in any case. That was more the idea as opposed to us taking over the case entirely. It just didn't come to fruition.
And since that time, I mean, there's been no acceptance of the help that you're aware of from your offices or the Attorney General's, from the Circuit Attorney's perspective.
Not that I'm aware of, no, sir.
Okay. Relating to St. Charles County, I know I mentioned it earlier. I believe you were in the hallway. Have you seen an increase in our county, and to what extent, of violent crime, petty crime that is related to perpetrators coming over from St. Louis?
A dramatic increase. I would say over the last 2.5 to 3 years, roughly coinciding with the onset of the pandemic, we're seeing younger individuals, many juveniles, many of whom have addresses in the city, many of whom I know have been arrested by juvenile authorities in the city and released, many of whom are shocked to find out that they don't get released in St. Charles County. We also have several individuals who are facing charges or are on bond in the city, and they come out to St. Charles County and commit other crimes. So that's happening. I can't tell you specific statistics, but I can tell you anecdotally anyway that it's happening at an increasing rate.
So I got a two-part response. What do you attribute that to, if you can, the increase of crime and the correlation to the perpetrators being from St. Louis?
That's a difficult question to answer. I can tell you what I know, and what I do know is this. When some of these folks are interviewed after being arrested for a crime in St. Charles County, they are oftentimes surprised and shocked that they're not only going to be held, but in some cases held without bond or on an extremely high bond. I don't think that's customary in the city. Again, I don't practice in the city, so all I know is what I read, what I hear. And what was the other part of your question, sir?
Well, I think, based upon I'm trying to figure out how we got to this point. What do we attribute the increase of crime? What do we attribute the spread of crime into surrounding areas? And in my opinion, and I would love to hear your opinion, it's almost like the very basic broken windows theory. What is allowed in the city of St. Louis, where traffic offenses are not prosecuted, violent crimes are not prosecuted. There are over 4,000 outstanding cases. And I believe, especially when these youngsters get involved, if you don't discipline your kids at home, they're going to go out to school, to their job, surrounding areas in the community, and have that same bad behavior. Criminals the same way. So do you believe that having 4,000 outstanding cases in the city of St. Louis is attributing to the increase in crime? And how do we combat that, if not with this bill?
I believe that the way you address violent crime is you have to hit it swiftly, hit it hard, mandatory incarceration. I think that's got to be the starting point. Everything else, there's room for discussion. But the violent offenders, people that show that they're capable of committing violent offenses or that they have violent tendencies, incarceration is what is best, maybe not for that individual, but best for the community. That's what needs to be done, in my opinion, whether it's the city, whether it's Platte County, whether it's St. Charles County.
I know you mentioned juvenile cases. As this bill is going to move forward, is there anything related to juveniles and certification that needs to be addressed that you would like to see at a prosecutor's standpoint, knowing that there are certain juvenile officers in areas like the city of St. Louis that are not even taking this to a certification hearing?
I will tell you, and I'll defer to Eric to answer as well, that's been a big source of frustration for us because we've had individuals taken into custody in St. Charles County. Well, as you know, if they reside in a different jurisdiction, that juvenile office also has jurisdiction over the child. That's something that I think is problematic. The other thing that's problematic is our county, for example, does not look at the statistics in terms of whether or not to certify an individual the same way that other counties do. I think if we can establish uniformity in that regard, I think that would be a tremendous benefit.
Yeah, and Senator, I'll just add two things to that. Missouri is relatively unique in that the juvenile system is completely separate from the adult prosecution system. That's the exception, not the rule in most states. In most states, the prosecutor who handles adult cases also handles juvenile cases, often with a specialized juvenile unit, of course, because the issues are a little bit different. But so that in and of itself is somewhat unique in Missouri. The other thing that we've talked about a lot, and I'd like to see, is a role for prosecutors in the certification hearing to be able to at least suggest to the court and to perhaps ask for some juvenile cases to be certified. Right now, prosecutor can be in that hearing, but doesn't necessarily have a voice in certification hearing. There are cases that I think it is appropriate to handle at the adult level. I'm not sure that happens all of the time.
And lastly, I want to focus on something that the circuit attorney said the other day. And as an attorney, I did my due diligence, looked at these cases involving the defendant Daniel Riley. And it's been stated that there's a local rule allowing for oral revocation motions in the city of St. Louis. I couldn't find it in the local rules. Didn't know if either of you were aware of that. But in those cases where an oral motion is made, how often is that not memorialized, whether it's the motion or the judgment, in the record thereafter?
My experience would say that if there is any sort of oral motion, whether it's to revoke bond or anything else, the parties involved will write out a memo and have that memo signed off on by the court. That's my experience.
And typically that'll be reflected in the court record, which attorneys have access to via CaseNet.
Correct.
Did you all see any of the memorializations or the record reflect the fact that bond reductions or revocation hearings motions were made consistent with what the circuit attorney stated on air?
I can't say that I have looked deeply into the Riley case, but I will tell you that in Platte County, if there were an oral motion, the practice is that it be reflected in the docket entries that would be then published on CaseNet and publicly available.
Well, I've looked through all of the relevant cases. I haven't found it. So, gentlemen, if you were able to find that information, you know how to contact me. Feel free to send that my way. I appreciate you all coming down.
Thanks.
Thank you.
Any further questions for these witnesses?
Yes.
Senator May.
So I have this question. First of all, you talked about the quo ronto that is getting ready to take place. Is there do the circuit attorney, can she appeal that decision, or is it non-appealable?
It's appealable.
Okay, so that could draw it out longer as well.
Could.
Okay, another question. I know that my colleague talked about, assistance from St. Charles and the Attorney General, the prior Attorney General. So I know those relationships are strained because if you're looking at the actions of Eric Schmidt and his performance in office as Attorney General, I can understand why she wouldn't take his help, because I wouldn't either. So so that's neither here nor there. But let me ask the prosecutor's office this. I mean, you said that there was no help, requested or any help received. Did you, after, I'm not sure that if any of this is true, they're talking about the number of prosecutors in the office. I haven't, I don't know if that was substantiated fact, but in your experience, if a prosecutor is coming on or what, did anybody go there to offer help, or did you offer any assistance other than for that case?
The offer of assistance was for multiple cases, a general offer by multiple prosecutors to assist if needed.
Okay, so
Not a single case, but multiple cases.
okay, very good. And on none of those cases was that assistance accepted?
Correct. That's my understanding. I didn't have the conversations directly. But.
I will say this, Senator. Early in the current circuit attorney's first term, due to some conflicts with the people she brought on board as attorneys in her office, there were several cases that needed special prosecutors, and MAPA did offer, and the offer to help was accepted. I think this goes back to 2017, maybe.
Mm-hmm. Okay, so they were accepted in
Correct.
those cases. Okay, and so this is my other question. What has COVID impacted? How has COVID impacted the judiciary and the prosecution of cases since 2020?
Yeah, the COVID backlog is real. It undermined the criminal justice system just like it undermined other systems throughout the United States, and there's no question COVID was harmful to the interests of criminal justice.
Okay, very good. Thank you.
Further questions for the Prosecuting Attorneys Association? Senator Roberts.
Thank you. Thank you both for being here today. I just had some questions as far as kind of distinguishing this piece of legislation from what we heard in special session, giving the Attorney General concurrent jurisdiction. I see here on the first and second page, it talks about how the special prosecutor will have exclusive jurisdiction to initiate and prosecuting the following offenses. So first-degree murder, second-degree murder, assault in the first, assault in the second, robbery in the first, robbery in the second, vehicle hijacking. I mean, those are some of the most serious cases that a prosecutor can try. And, one of my other concerns is you're in effect weakening that office because you're not allowing any of the assistant circuit attorneys to handle those types of cases. So how much harm are you doing to the region when you're saying, all right, these are the most important cases in your area that folks in your community, your prosecutors are going to try. You all aren't going to try those cases.
Senator, I think that's an excellent question, and I would extend on it also. As I mentioned, right now there's a difficulty recruiting assistant prosecuting attorneys all across the nation. Recruitment's at an all-time low for prosecutors. And so if this bill were to pass, we'd be setting up, frankly, the likelihood that those assistant prosecutors who would join the special prosecutor would likely be recruited from our offices. By their very nature, they're going to have to be experienced prosecutors. And so that's a difficulty. The other thing that is interesting, as you mentioned, the cases that could be prosecuted and wouldn't be prosecuted by the special prosecutor. It's a little bit interesting to note that in the tragic case that we've been talking about, and fortunately, that young girl, though seriously injured, survived. Had she succumbed to her injuries, that likely would have been a manslaughter case that the special prosecutor wouldn't have authority to prosecute. So the selection of crimes that this bill turns over to the special prosecutor is interesting. We've mentioned that it doesn't include armed criminal action, which, as you all know, Senator, is often a subsidiary charge if there's a weapon used, as there is in the vast majority of murders and assaults and robberies. And it doesn't appear that this legislation gives the special prosecutor the authority to prosecute those sorts of actions.
Right. And just to build on that, it specifically says that this special prosecutor shall not be required to reside in the jurisdiction. And then more so than that, the special prosecutor shall be paid the same salary as a state circuit court judge. So you've got someone who's may not even live in the area, and they're making more than they probably would make as an assistant prosecutor on top of that. And then briefly to touch on something that wasn't brought up that's in the bill. I mentioned this earlier, but I believe you all may have been in the hall. There's the section in here, if you've had a chance to look at it, where it changes the unlawful use of a weapon as far as a dangerous felon from, felons aren't allowed to possess firearms, to changing it now to dangerous felons. So this would exclude someone who commits, this person would be able to carry a gun, a person who's convicted of assault second. So that's someone who attempts to cause or knowingly causes physical injury to another person by means of a deadly weapon or instrument. Now we're saying they can carry guns. Someone who's been convicted of stalking, felony stalking in the first degree, statutory rape in the first degree if the victim is 12 or 13 years old, voluntary manslaughter, which is when someone knowingly causes the death of another person, or with the purpose of causing serious physical injury to another person causes the death of another person. Could you all talk a little bit about that and that changing to the firearm part of a dangerous felony?
I would say, Senator, as it relates to individuals convicted of those offenses you enumerated, they should not be entitled to possess a firearm. So that's very problematic, to say the least.
Thank you.
Senator, I'll mention too, and we've had discussions with Senator Lukemeyer about other provisions of this bill that we've not addressed in our testimony today. That's one provision that we have concerns about. We have concerns about a couple of other provisions as well. We'd be happy to have offline discussions with any member of the committee about some of the other portions of this bill that we think are troublesome. There are other portions of the bill that we think are good.
You're done. Mr. Chair, I have a follow-up question.
Senator May.
So I neglected. I can't even say it today. I did not ask about the oral argument conversation. So it was suggested, in the media that because there was no record that it did not take place. But that's not the case, because what she said was substantiated by the other attorney, because he said he argued on the other side and the judge sided with him. So what is the practice? I mean, is it in statute, or is that just like something that judiciary and lawyers do, or what is the practice? Is it rule or what?
Sure. Every circuit has its own individual court rules. The Supreme Court establishes certain rules, operating rules of procedure, and then the local courts can establish their own rules within the Supreme Court rules, if that makes sense. So, and they do vary from jurisdiction to jurisdiction, for sure.
Okay. So this could have very well been the case.
Could have been.
Thank you.
Any further questions for these witnesses? Seeing none, thank you for your testimony.
Senator, if I might just, I want to say what a privilege it is to have you, Mr. Chairman, as my senator. Thank you for your work here in Jefferson City.
Thank you, and it's a privilege to have you as my prosecutor. Appreciate you both being here.
I'm going to pray for you.
Further,
Senator Shore, it's a privilege to have you as my senator as well.
It's a privilege to have you as my prosecutor.
All right, now that we got that love fest out of the way. Appreciate y'all being here to testify. Further witnesses in support of Senate Committee Substitute for House Bill 301.
You can proceed.
Hello, my name is Jim Dandridge. I am a retired sergeant from the St. Louis Metropolitan Police Department, but today I'm here as a father. My son is the individual involved in this Daniel Ray case in which Kim Gardner's office indicated was deceased. My son is not deceased. He is live and healthy as any other boy can be. To tell you the story how this all occurred, 3 years ago, my son was robbed at gunpoint by 3 subjects. One of them being Daniel Raleigh, since everybody's already said his name. The other two at this point I'll just refer to as suspect number 2 and suspect number 3. So that was in August of 2020. Last year in August, we go to trial on Daniel Riley. The prosecutor from Ms. Gardner's office says, I'm overworked. I just got back from my honeymoon. I'm not prepared to go forward with this case. The judge is like, well, this case has been sitting there for 2 years now. And she goes, well, what we'll do is dismiss the case and then take it to grand jury again and go from there. Well, myself as taking many cases to grand jury as the policeman in the city of St. Louis, no, that ain't always true. Sometimes the grand jury will indict and some won't. Anyway, I have no choice. We go forward. What I didn't know, though, is that in January of this year, he was taken to grand jury and a true bill was issued again, which I was never notified of that at all. So now we're up here where this young lady gets injured downtown, and I am approached Tuesday of this week indicating that it was Daniel Riley and that the prosecutor's office is indicating that the ankle bracelet that he was wearing was due to my son being the victim of robbery who was deceased. So I find this kind of odd. I mean, if he is deceased, I think someone should have called me. If the circuit attorney's office is following up with their victims as they should, they would have known that he wasn't. So I say, well, I'm going to call the Victim Service Bureau of the circuit attorney's office. So I get a hold of them on Tuesday also. They inform me, well, yes, your son's deceased. I'm looking at him across the table in the kitchen. Obviously, he's not. And they say, well, hold on for a minute. Let me get back to you. They come back a few minutes later and says, well, this is an error. Apparently, let's go with suspect number 2. We'll just call him suspect number 2. Was involved in a violent crime with another individual with the same first name as yours. Inadvertently, somebody must have checked the wrong box indicating that your son is deceased. We will get this fixed immediately. Okay, mistakes happen sometimes, but I'm also hearing that during this basically 2.5, 3 years, Mr. Riley has violated his ankle bracelet approximately 100 times. Mind you, this is for a violent armed robbery and armed criminal action. So I'm assuming you're going to make everything right. Wednesday comes around. I get a call from a friend in the media and says, have you looked at the charges from suspect number 2? I said, what do you mean? That same day on Tuesday, he had a hearing that I wasn't aware of involving my son's robbery case, and there was a motion by the defense attorney to dismiss the charges because, guess what? My son's still deceased. The prosecutor agreed with this motion, and the charges were dismissed. I called back on Wednesday when I heard all this, and so they say they're going to go forward and issue the case. So as right now, I believe the case has been issued. But something that you should know then is that suspect number 2, he was under house arrest too with an ankle bracelet, which he decided to disregard as well. I don't know how many times. I didn't count it all. Doesn't matter. He shot an individual with the same first name as my son. Approximately 4 minutes later, this is all in 2022, he's a victim of a homicide in the city of St. Louis. So that's how they went back to suspect number 2, who's connected to my son's case, and said anybody with that first name inadvertently is deceased. And here we are talking about this. So, I mean, this was an armed robbery. I believe all 3 suspects should be confined on an armed robbery. We're not talking about somebody breaking into cars. This young lady wouldn't be an amputee. Also, I believe that the prosecuting attorney's office has a right to tell victims like my son and I, if this person's under house arrest and he violates it, that he's on the street, and be careful and be aware that the suspect is on the street. Apparently, if you look at all 3 suspects, I have the names and everything if anybody wants it, cause numbers. They've all multiply violated this house arrest thing with the ankle bracelet. I believe that the circuit attorney's office has failed my son. Here we are, it'll be 3 years this August, and the case is still pending. I believe now at least 2 of the suspects are now confined. Mr. Riley, suspect number 2, who the case got thrown out but got reissued. I'm not sure about suspect number 3, but I believe that she failed all of us. I mean, this young lady, once again, would have her legs, and we wouldn't be here talking about this, or at least I wouldn't be here talking about it. But That's how I came here as a parent, explaining to everybody how this all occurred. There's anything else I can say, but I mean, I'm open for any questions.
Good. Thank you for your testimony. Any questions for the witness?
Yes.
Senator May.
Where did this take place at? This robbery?
4100 block of Finney.
4100 block of Finney.
Correct.
And where do you live?
South St. Louis.
Okay. Thank you.
Any further questions for the witness? Senator Roberts.
But I just wanted to say we appreciate you so much for coming up here, and what happened. Your son's experience was completely unacceptable. So thank you for being here and providing your testimony.
You're welcome.
Any further questions for the witness? Seeing none, thank you for your testimony, and please fill out a witness form if you haven't done so already. Great, thank you. Can I get a show of hands? How many further witnesses in support do we have? And then witnesses in opposition, how many do we have? Okay, we've also got additional witnesses outside. So we're going to take an additional witness in opposition now. We're going to limit testimony to 2 minutes. So next witness in opposition. And apparently there is somebody from the circuit attorney's office outside, so we're going to let them go ahead and go first in terms of witnesses in opposition.
You got a few more out in the hallway, too. Which stack is for and which stack is against?
You just put them in either one, and we'll sort it out later.
So understand I just have 3 minutes, and I'll be brief. My name is Reddit Hudson with the Office of St. Louis Circuit Attorney. I was here in January for the House hearing on HB 301, and at that time, I think it was the number of homicides that was referenced in the initial hearing as one of the primary drivers for the bill. The number of homicides under this circuit attorney. It was a baseless premise, as established at that hearing. For example, they were talking about that as if that's new. But in 1982, 41 years ago, there were 226 homicides in St. Louis. 1981, 264 homicides in St. Louis. 1972, 205 homicides in St. Louis. 1971, 220. 1970, there were 266 homicides in St. Louis. It was pointed out that there could have been some population differences that could have skewed those numbers. So what we did then was zero in on a period of 5 years, 1991 to 1995, where the population is very much comparable to what we have now. During that 5-year period, there were 1,210 homicides in St. Louis. 1,210. There was no move by the state to replace then Circuit Attorney D. Joyce Hayes. There was no move to disenfranchise St. Louis voters. St. Louis was still vital to the region and the state at the time. And all of the many murders that happened during those years happened while the state had control of the police department. That's what state control gave us. I know because I was a police officer at the time. A recent horrific tragedy in St. Louis involving a young lady, Janae Edmondson, amplified criticism of the St. Louis Circuit Attorney, and the issue was framed erroneously as her having allowed Daniel Riley to remain out on bond, but Daniel Riley was out on bond because Judge Brian Hiddenbach allowed him out on bond. Much has been made in the media of there being zero record. There's no record of any oral argument or any oral effort on the part of the Circuit Attorney's Office to address the bond issue. I spoke personally to the young lady who made the oral argument in front of Judge Hiddenbach, but I know, sometimes word of mouth won't get it. So I brought documentation instead. Here's the court order from Judge.
Rather than reading the court order to conserve time, why don't you
leave
a copy of it?
He did it. I'll make a copy of it.
And we can distribute it to the members of the
That's
committee.
fine. But I do want to zero in on some language with the few seconds I have left. The court has received, this is the court order from the judge, the court has received multiple and repeated notices from pretrial release of GPS violations by the defendant. Lawyers have taught me that it is a judge who has the ability to revoke. He set a hearing on this date after it had been brought to his attention. Here's the ruling from the date that he had the hearing on the bond for Mr. Riley. The court has reviewed the bond, this is a court record, the ones that there's zero evidence of. Here it is physically, in reality. The court has reviewed the bond and leaves the defendant on GPS. Case is set for July 18th, 2022. He left him out. Here's what I'll say, man. The fatal flaw, I just wanted to touch on those two things, but the fatal flaw in this legislation is that it disenfranchises voters in St. Louis, particularly black voters in St. Louis, who voted overwhelmingly for St. Louis Circuit Attorney Kim Gardner to do the work that she's doing. These attacks on her, Chris Hinckley came with me last time from the office. He's an attorney. I am not. He was able to effectively address some of the procedural issues that were raised. That's not my space. But this bill is an effort in no uncertain terms to disenfranchise voters in St. Louis, and in my personal opinion, to punish an independent black leader in the city of St. Louis who has delivered on her promise to address systemic issues in the system, demonstrated by holding powerful people accountable who have no expectation of being held accountable. I'm thinking about former Governor Greitens. I'm thinking about the two attorneys that flourished peaceful protesters as they walked down the streets of St. Louis, and she's being punished for it. Here we see Lamar Johnson, a man who was in prison for 28 years, now free through the efforts of this circuit attorney, because unlike prior circuit attorneys, she didn't go with the status quo. She actually looked at the facts of that case and recognized some of the police failures and prosecutorial failures that resulted in his loss of liberty, and now he's out. And I think that status quo defenders all over the state have responded thusly. So I'm sure that's my 3 minutes. I'm ready for your questions.
Thank you. First of all, I'm happy to hear that the circuit attorney is taking credit for the freeing of Lamar Johnson. Do you know whose legislation that was that resulted in him being freed from prison?
I know she's the only circuit attorney that would have taken up that legislation.
It was my legislation.
But didn't she have to create that legislation because she was told that she didn't have standing to take the case?
She relied on private attorneys to litigate that entire case.
Did she not get told that she did not have the standing to take the case, and that's why the legislation had to be introduced?
She was told by the Supreme Court, just like she was censured by the Supreme Court for unethical conduct as a prosecutor. She's been told a lot of things by the Supreme Court.
Yes, she has. But she's been voted into office by the people of St. Louis overwhelmingly with all of that information available.
So let me ask you this question. Why is the circuit attorney not here today?
You would have to ask the circuit attorney. I don't.
Well, no. I mean, it strikes me that this is a law that is addressing her systemic failures in the city of St. Louis. And yet, when there was a hearing on this legislation in the House, she was a no-show. Whenever she saw the notice for this hearing that resulted in you coming down here, she didn't show up. My question is, why is the circuit attorney not here herself defending her record?
She's busy working for the people of St. Louis.
So let me ask you, working for the people of the city of St. Louis, does that include having a 50% conviction rate for homicides?
That's not correct. I don't think that's correct. I think the number is closer to 80%, but you would have to speak with somebody who directly works with those numbers. But I don't think 50% is correct. And I would say this, can I go on the record with this? I think we need to drill down and get the actual factual documentation of what that number is, because I think that's incorrect.
So the news media from multiple outlets,
the news media said there was no records of this,
including multiple broadcast outlets in the city of St. Louis, including the St. Louis Post-Dispatch, which is not exactly a conservative publication,
but it's not exactly a credible publication.
Let me ask you this: all of those media outlets are misrepresenting case numbers that they have from the circuit attorney's office they've analyzed.
No, all of those media outlets told me there was no record of this. So what do you want me to do? Either they're credible or inconsistent. I don't know the answer to that, but I wouldn't rely only on what media outlets are telling you, especially when they consistently, over time, have shown a bias towards leadership in my city. You may not be from St. Louis. I am. So take my word on it, man. The media there, you don't always want to go hook, line, and sinker with what they put out to you.
Okay, let me ask you, in terms of the cases that are actually charged by the circuit attorney, she herself said that 60% of the cases that are brought to her by law enforcement are not prosecuted. Do you know why? More than half of the cases
That would be a question for Chris Hinckley. I'm not an attorney, and he's not present here today.
So why were no attorneys sent down here today to testify?
You'd have to ask the circuit attorney.
Okay, so the circuit attorney's not here to testify, and she didn't bother to send any attorneys from her office down here to testify before the Senate.
But I am.
Okay. Any further questions for the witness?
Yes.
Senator May.
I want to thank you for coming down to testify. But, I will go on the record to say the reason why she's probably not here is because, just like you said, she's defending the office. Because if she wasn't defending the office, then that will be said as well. She would be
we recently had
attacked on that.
A lawsuit launched by an unelected attorney general. So, yeah, it creates new busyness.
Well, we know when people who are appointed or trying to run for office and they're challenged, we have to create a platform for them in order to, win, and that gets them media. So let me ask you this question. In all the years you've been in St. Louis, is it surprising to you that all of these outside entities and representatives are focused on St. Louis the year that we have an African-American mayor, African-American prosecutor, and other African-American local government officials?
Not at all. Not at all. Black leadership is always under attack in St. Louis, and that's what I was referencing earlier. When you go back to Freeman Bosley, go back to Chief Henderson, go back to Chief George, salt of the earth. But when he effectively moved to make substantive changes that would benefit black firefighters, he came under attack by the local media. And you referenced the media to me? The media in St. Louis as a credible source of something that I should stand on as anything to rely on?
Right.
Nonsense.
Absolutely. And is it your, perspective that in the city of St. Louis, that this overall issue is systemic of the history of the city and the polarization that has taken place in the city?
Absolutely.
And also from the state.
Sure. I mean, we can sugarcoat it and dance around it, but in many spaces, valuable political currency is what damage can we do to urban centers. That's political currency in both in language and deed, which is why I'm in opposition to this bill in both its spirit and letter, because this is coming from that place. We know it. You can couch it in legislative language, but I don't think, for example, Missouri has the unique distinction in 2017 of being cited by the NAACP and hit with a national travel advisory. That has never happened in the history of that organization. Not Alabama, not Mississippi, not Georgia, not the Carolina. Missouri was hit with a travel advisory due to systemic issues relative to racism. We didn't then say, did the federal government come in and say?
I'm glad you mentioned that, because that incident that warranted the NAACP for issuing that notice was due to a police chief in rural Missouri assaulting an out-of-towner, keeping them locked up in prison, assaulted them, killed them while in custody. And I remember going to the Attorney General then, and he refused to prosecute or look into that case. That was Eric Schmidt. Yeah. So I don't know if today that has even occurred, but that's why that advisory was issued. And so the state didn't take up anything in reference to the prosecutors in that state, because they didn't prosecute that police officer, that police chief.
I'm surprised by Eric Schmidt, because he's such a law and order guy that you would think he would have went after that case.
Okay, thank you.
Any further questions for the witness? Senator Roberts.
Briefly. Earlier, the Missouri Prosecuting Attorneys Association, they testified against this piece of legislation for a multitude of reasons. But one of the points they did make is that they would be willing to help if there was any backlog. There was some backlog in cases just caused across the board due to COVID. And if you're not able to comment on this, I understand. But do you know if the circuit attorney is willing to take help from outside prosecutors?
I would surmise that in the context of genuine help is not looking to displace her or her role as assigned to her by the people of St. Louis. She probably would, but I can't say that definitively.
Thank you.
Any further questions for the witness? Seeing none, just make sure you have a witness form and leave that behind.
Yeah, I got it right here, man.
Great. Further witnesses in support? And we are going to limit the testimony to 2 minutes. Thank you.
I'm Michelle Shanahan DeMoss. I am the mother of Blair Shanahan Lane, the 11-year-old little girl that was fatally struck by a bullet on the 4th of July, 2011. So as we shift for just a minute, this bill was filed, Blair's Law, first more than 10 and a half years ago by Representative Mark Talboy. And this is my second time testifying in the Senate, and really my first time moved so emotionally that it is difficult to speak. It is to be in such a controversial situation as it is. A bullet traveled 3 football fields, striking my daughter in the neck. The bullet didn't know a name or face. It was fired recklessly by somebody that had a conceal and carry license. The gun then was shared and used as though it was a toy. Blair held the slug in her neck, which was able to be used to identify the weapon. The gun, 11 years old, should be 23 years old. And I'm here again. I have spent more than 11 years. People use the word tirelessly, but I'm not going to say I'm tired because I vowed that I would keep doing this and keep talking about it. I'm sure I could probably take a survey in the room, because every 4th of July, every New Year's, the conversation is continual about using a gun recklessly, and that gun was used recklessly. But the crime is a misdemeanor, and I am here because I believe it needs to be a felony, and it needs to be a crime that can be prosecuted, not something that is suggested that they have to be creative on what they do. We may not find who shot the gun. The sunlight shown on the more than 50 shell casings, that is how the detective found where the gun was being fired from. Blair was being loaded in the ambulance, and the police officers make mention they could still hear the gunfire. I was just mother of a 11-year-old little girl, a stepmother of 4 children, a foster parent, enjoying the 4th of July. Really irritated by the smell of those smoke bomb things. Didn't like the sulfur smell, but enjoying the evening, having a good time. When Blair fell, I basically caught her and kept her alive so she was able to donate 6 organs, giving the gift of life to 5 people. And, I'm here, and I will keep coming back here. I have, there isn't a term limit for me to keep raising awareness, to keep standing behind something. I have walked year after year. COVID did affect going door to door, knocking on people's door, raising awareness, having people realizing that, or having us realize that by stiffening the penalty of the crime, people are more able to call the police and know that something's going to be done. if something's able to be handled. So I'm thankful for this opportunity, and I guess I'm just going to close with that. Like I said, it's a lot for me to be here today. I mean, is anybody? I have a lot of opinions. I have a lot of statistics from my own situation, and I believe by stiffening the penalty of the crime that is currently a misdemeanor, 100 hours of community service. And I will tell you, my 5th grader could have followed better rules than 4 adult men, because I don't believe any one of them finished that community service. The focus is not on them. The focus is on the people that have continually to fire guns irresponsibly, shooting them in the air, shooting them in the ground, shooting them every which way. That's not how a gun is intended to be used. Once the bullet leaves the gun, it maims or it kills. It killed my daughter, and it has maimed me for life.
Thank you, ma'am, for being here with your testimony. Thank you for your bravery and coming forward and telling your story.
And I apologize about the emotion. Like
No, it's very much
could have
understood.
stood in a closet or something till it was my turn.
Very much understood. Thank you for being here. Any questions for this
Yes.
witness?
Any questions?
I just have a comment.
Senator May.
I want to thank you for your bravery as well, but I am definitely in favor of making it illegal and stiffer penalties for just willy-nilly firing a weapon on the 4th of July.
And it's
it
not just the
destroys
4th of July.
That's right.
Thank
New
you for
Year's too.
Yeah.
Absolutely.
Tuesday, Wednesday, it shouldn't
Absolutely.
be fired that way.
Absolutely.
Thank you for your testimony.
Thank you.
Further witnesses in opposition to House Bill 301.
You know, Adolphus Pruitt, President, St. Louis City NAACP. And Mr. Chairman, yeah, it's on. I am shocked when I come before this body and I hear that we're debating legislation, creating legislation, and it's based on not the record, but based on what is broadcast in the media as a source of information. I did not expect that today. I would say this quickly. The chairman talked about kids with guns, and he mentioned in St. Louis, if you go to the Warren County record, on February the 3rd, they talked about a 3 charge with giving a toddler a loaded gun. He was 1 year old. That was in Warren County. That's where the Attorney General stays. It is amazing to hear the St. Charles County prosecutor talk about violent crimes in mandatory terms when last year a guy pled guilty to making 3 hand grenades, a claymore mine, and 2 pipe bombs with the intent to blow up black people if they came out to St. Charles protesting. And he got probation. But he talked about mandatory.
Hang on just a second. I'm going to ask members of the audience just to remain silent during witnesses' testimony so the committee can hear. Everybody's going to have an opportunity to come up and speak, but just for decorum purposes, please remain silent whenever testimony is happening.
Yeah. And he talked about mandatory for violent criminals. I don't know how much more violent you can get is to make bombs with intent to blow up people. And the part that gets even stranger, we talked about back case laws. When Kim Gardner came into office, there were 32,000 cases under advisement waiting for her. 32,000. And we talk about 3,000 here, when out of that 3,000, the police department dumped 800 of those into the record in January, and included in those that they dumped in were 36 cases that was over a year old for resisting arrest and drugs. There was 116 that were 2 years old. There was tampering that was 2 years old, 34 cases. There were all sort of felony and dangerous cases that were years old that the police department just turned over to the prosecutor in January with an 800 file dump with the intent to influence this legislation and influence this committee. And nobody's investigating the police department about that. That is, I mean, those victims, nobody's doing anything about those victims that the police department sat on those cases for years.
Sir, so we have actually reached well over 2 minutes.
Sure, I would say this also. Statistics, overall felony rate for the prosecutor's office, 2015, 97%, 2016, 98%. This is Gardner getting in office, 2017, 97, 2019, 96. As relates to homicide rates, 86%. So I don't know. You're getting your numbers out the press. We getting ours from the courts.
Sir, let me do this. Thank you for your testimony. I'm going to ask the witnesses or any of the senators if they have questions. If you have any statistics that you would like to be made available to the committee, if you could please leave that on top of the witness pile, we will make copies and make sure that gets distributed to members of the committee. Any questions for the witness?
And Mr. Chair, I just would like some latitude. I know that we're pushing up on time, but the same time and respect we gave those in proponents of the bill, we want to give it to those in opposition.
We will be enforcing the same time limits on proponents of the bill as well. So,
one other quick fact: he spoke about the case with his son, and that they stopped it and refiled it. Where the defense attorney wrote that he came there and he was not prepared to go to trial. He and the prosecutor's office thought they had a plea agreement. The plea agreement fell apart. That was the only reason why that thing didn't proceed. That's the only reason. This is what the attorney for the defendant.
Thank you, sir, for your testimony. Appreciate it. Any questions for the witness? Seeing none, thank you for your testimony.
Yeah. And this wasn't in the paper, by the way.
Further witnesses in support. Any other witnesses in support?
Jane Duker. I represent the St. Louis Police Officers Association, St. Louis County Police Officers Association, and the Missouri Fraternal Order of Police. Just to remind the committee, the Office of Prosecuting Attorney in the City of St. Louis is solely a creature of state statute. The city never enacted anything related to the prosecutor in their charter, so it always has been a state issue. So I just wanted to clear that up. Also, what we haven't talked about is federal intervention. Typically, the feds would handle 600 cases in the city of St. Louis, drugs, guns. They're up to like 2,100 a year. So they are picking up the slack where the circuit attorney's office is falling behind. This committee should look into the fact that there were instructions given to assistant circuit attorneys not to charge armed criminal action in cases because it would enhance penalties. That's a problem when we're dealing with gun crimes. Armed criminal action is an essential part of a case in order to deal with gun crimes. So I think that's important. I think when you talk about victims coming forward, there's been legislation, there's been money given both at the state level and at the local level. The problem is the victim services unit is decimated just like the rest of the prosecutor's office. So that probably does lead to issues involving victims. And in 2018, a bombing suspect was released for failure to adhere to a speedy trial. 2020, murder charges were dropped for failure to attend multiple hearings. April 2022, murder charges dismissed because of the failure to turn over records to the defense. Also, we have poor Xavier Uzanga, who was shot playing near his house. The person who shot him admitted that they shot him, and the prosecutor has still failed to file charges for murdering that child.
Jane, we have reached 2 minutes. Thank
Great.
you for your testimony. Any questions for the witness?
Absolutely.
Senator May.
Where are you getting your facts?
Which ones would you like? Which facts were you talking about? And I can tell you where I got them.
The ones that you were quoting.
Well, the statute, the idea that the prosecutor is governed by statute.
That statute. I'm talking about
which one?
The quotes that you were talking about, the number of cases and all of this.
I didn't talk about number of cases.
You just gave a lot of facts?
I mean, I stated facts, but I didn't.
Were
the
they
number of
facts?
cases-
Where are you getting your information in reference to
well, the policy of
what
not-
they prosecuted? You
Oh.
said they didn't prosecute this, they didn't prosecute that.
Oh, yeah, no, those are all in court records. Those are not even from the circuit attorney. People have been asking, the Board of Aldermen, the press have been asking the circuit attorney for her data on convictions rates for 3 or 4 years and have never received it.
Right, I wouldn't give it either. So let me ask you this question.
And it's hard to.
So tell me about this. So the state says that they don't have gun laws. They allow teenagers to carry weapons. They remove the conceal and carry requirement, but yet and still they want to say armed criminal action. It seems hypocrisy to me. Why are you going to say I got armed criminal action, but it's okay for me to carry the weapon? I'm trying to figure out.
Well, armed criminal action, you're committing a crime. So if you're using a gun and committing a crime, that's armed criminal action. It's not carrying the gun or possessing the gun. It's they use that when they charge someone for committing a crime with a gun.
But it has been abused in the city of St. Louis over time.
I think
They've
some would
charged
say
just to get mandatory sentences, especially on young African American youth in the past, and
Well-
so they attach it to everything on criminal action.
I mean, I think if you're gonna, and I'm a proponent of gun control. I worked for a governor who vetoed. Personally, I worked for a governor who vetoed conceal and carry. I mean, I get it, but I also think that it's difficult to ask for more gun laws if you're not going to prosecute the use of guns. What makes anyone think you're going to prosecute the possession of them? And so I think what the struggle that we're having is that gun crimes are not getting prosecuted. That is terrifying.
Well, the struggle that we're having is the fact that we don't have sufficient gun laws to prosecute. That's the crime. So thank you anyway for your testimony.
Okay, thank you.
Further questions for the witness? See none. Thank you for your testimony.
Thank you.
We are going to do oral testimony from one more witness in opposition to keep it even in terms of the number of witnesses for and against. Any other witness that is here that would like their name entered upon the record, though, can fill out a witness form, and we will make sure that makes it into the committee's minutes. So one further witness in opposition, and it'll have the same 2-minute limitation as the other witnesses.
Good afternoon. Thank you, Mr. Chair. My name is Darrell Gray. This is a bill looking. This is an expensive solution in search of a problem. Assuming that a special prosecutor is appointed and hires a full-time staff, the program will cost the state of Missouri about $3.5 million a year for each year the special prosecutor exists. That money could be spent on a number of proposals currently pending in this legislature, including teacher salaries. Instead, the money will be spent on a duplicate government office that won't have any more access to quality policing or court dockets than the current police prosecutor does. I chaired a task force, a corrections task force under Mayor Lyda Cruson. And we looked at why there was so many inmates in the detention center. We looked at why the bottleneck within the criminal justice system. And what we found was that a lot of different parties contributed to this bottleneck. The police contributed, the circuit attorney contributed, the judges contributed, the institution itself contributed. We believe very much, Mr. Chair, that this is in fact an attack on an African American elected official. Regardless of what people might say, the gentleman that's here, I don't doubt his heart, I don't doubt his conviction, but the reality is if you ask African Americans in this state, most African Americans in this state honestly believe that this is racially motivated, that it has racially maybe not blatant attempts of racism, but it is racially insecure and it is racially insensitive, particularly in light of what we're dealing with right now in St. Louis. Democratic President Andrew Johnson gave his annual message to Congress on December 3rd, 1867. And in his message, Andrew Johnson, former president, said, "Negroes have shown less capacity for government than any other race of people. No independent government of any form has ever been successful in their hands. On the contrary," he said, whenever they are left to their own devices, They have shown a constant tendency to relapse in barbarism. The statement that Andrew Johnson made in 1867 seems to be the exact same premise that this particular piece of legislation is shrouded in. And as I listen to the mother who lost her child, it is a shame, Mr. Chair, that whoever put that bill in the midst of this has done a travesty to that woman and the death of her child. To hide something so relevant in something so irrelevant is a travesty and a shame. There's a lot of good pieces of legislation in 301 that should be heard, that should be passed, but this is not one of them.
Thank you, sir, for your testimony. Any questions for the witness? Seeing none. As I mentioned before, whether you're a witness in support or a witness in opposition, please fill out a witness form. Please leave that up front, and we will make sure that it's included within the record. And this will conclude
Hold
the
on.
hearing.
Mr. Chair, so we're now letting the other folks who came up to testify today?
We are taking written testimony from everyone else who's here to testify. There are witnesses in support who are going to be turning in forms and witnesses in opposition.
So, I mean, I've got constituents who drove over 2 hours to be here to speak. I mean, what if we just did a recess until we go into session at 4 and come back?
I'm not going to recess. Once we get into session, we can't come back into committee. Under the Senate rules, committees cannot meet during session.
Okay.
But I'm saying after session.
Look, I'm going to make an adjournment motion. That is my intention. I'm not planning on reconvening the committee. We've given an entire allocation for this hearing to one bill, which, as you know, is not normal for the committee. There are two other bills that we had teed up that are not going to be heard now and are going to be heard next week. So I'm going to be making an adjournment motion. Again, if anyone wants to leave their comments behind, we will make sure that those are reflected in the record.
But Mr. Chair, this is the only process that constituents have to come voice their concerns based on legislation that we passed in the state of Missouri.
Senator,
and I've been in committee hearings that have lasted almost an entire day because the room has been full. And we have given these patrons the latitude to voice their concerns. And I think it will be unjust to not allow them to speak.
Senator, the decision that I've made is that we're going to do written testimony for the remaining witnesses. Anyone is free to leave behind that testimony. This is including witnesses who are in support, and that is the decision of the chair.
Okay, so you're making a motion now to adjourn.
I am going to make a motion to adjourn, and anyone who wants to provide written testimony is able to do so, including witnesses in support of the bill, of which there are. Thank you.
I guess the Republican hit list is really important.
Go ahead.
What if we continue it next week then?
We can have a discussion online as to whether or not we want to renotice the hearing next week. We'll have a discussion. I would now make a motion to adjourn. Do I have a second? It's been moved and seconded.
I request a roll call. I request a roll call.
Roll call. Racism is real in Missouri. That's for sure. That's for sure. Master did that.
Red Scott revisited. We're trying to still go ongoing.
But other people had more than 3 minutes, and other people had more than 2. BOA had 4 minutes, and 46 seconds. Because our time.
It was obviously clear that they were here to steer this in one direction.
Exactly.
And they did that.
We would have had time for everyone to
Racism live
had
and real.
everyone been subject to the 3-minute time limit.
From the beginning.
From the beginning. And then all of a sudden, with the opposition, here comes the time limit, 2 minutes, for 3 minutes, then 2 minutes.
Take away the voice. You want to continue to take away the voice of black folk in St. Louis. That's what you're doing, Mr. Chair. You're taking away the voice of black folk. You want to do it through this. You want to do it through the legislation, and now you're doing it through the process.
He ain't worried about it.
You want to help us without us asking for your help.
Legislation shackles.
You ain't nobody daddy.
Listen, please. I would just ask everybody to just be patient. And please prepare to turn in your written testimony, please.
We will adhere to your request.
There's been a request for a roll call on the motion to adjourn. Brad, please call the roll.
Motion to adjourn. Senators Luetkemeyer, Schroer, Coleman, May,
No.
Roberts, Thompson Rader, Trent, 4-2.
By your vote of 4-2, you have voted to adjourn the committee hearing. The committee hearing is adjourned.
Racism in Missouri is real. And it was shown the state today. It was shown the state today.